Good morning, dear students. As you know, in our two precedent courses, we have examined the United Nations Organization by examining three topics. Topic 1, the aims and principles of the UN. Topic 2, the General Assembly. And then topic 3, the Security Council. By this way, we have examined all the topics that we have for the final exam. From today, we will begin to examine from page 221, I mean chapter 7, having the title of the UN Specialized Agencies. And with this regard, within chapter 7, we will have to examine from page 221 to page 241. From page 221 to page 241. From 242 to the end of this chapter, I mean to chapter 259, this is excluded from the exam. Then we have to examine only from page 221 to page 243. And within this part, from 221 to page 243, only one international specialized organization is excluded also from the exam. I mean the FAO, Food and Agriculture Organization. Food and Agriculture Organization. The last paragraph of page 230 to the beginning of the page 232. What we'll have to examine then in this chapter, chapter 7, from 221 to page 243, and by excluding the FAO. UN specialized agencies. Here we will have to examine three topics. The first one, a theoretical one. The first one is a theoretical one. What do we mean by the notion UN specialized agencies? Second and third topic relates to some examples of today existing UN specialized agencies. And within this matter, topic 2 will relate to the exam of the FAO. The second topic will relate, to the exam of the International Labour Organization, and the third topic will relate to the exam of the UNESCO. Then, number 1, the theoretical aspects relating to the notion UN specialized agencies. Number 2, the International Labour Organization. Number 3, the UNESCO. Topic 1. What do we mean by this expression, United Nations specialized agencies? As here, we have to examine organs of the UN. That is not right. That is not right. The UN specialized agencies are international organizations separated from the United Nations organization. Here we are within international organization as the UN, as the Arab League, as the European Union, separated each one of them from the other. In fact, if we remember our classification of the existing international organization of today, we have said that sometimes we are within IOs having more than one competence to achieve by their aims, as it is for the case of the UN or the Arab League, but sometimes we are within IOs having each one of them only one competence to achieve, and in this case we will be within specialized international organization. Specialized international organization. And in fact, here we are speaking, that is the title. In fact, when we say that the title of this chapter is UN Specialized Agencies, it is okay. We have to say that this chapter relates to universal, international, specialized organizations, in plural, which are not the UN and which are not organs of the UN. Here we are within separated international organization from the UN. Each one of them has its proper aim, each one of them having its proper principal organs, each one of them having their proper members, then also each one of them the legal system of the binding force of its resolution is not the same as for the UN. Why then we give to these universal, international, specialized agencies, which we will examine now, the name of UN specialized agencies, if I say that here we are within independent international organization, having each one of them is proper international legal personality, distinguished from the international legal personality of the UN, separated international organization. We have to give a signification for this matter. In fact, when the UN Charter has been concluded, and this in the Conference of San Francisco 1945, it has been stipulated, reiterated, that the UN will have to achieve more than one aim, 4 aims as you know, and between these aims, the promotion of cooperation between states in social, economic, cultural matters, and for the promotion of human rights. Cooperation between states as aim of the UN is economic, social, cultural fields have interdependence, in fact, within the activities of each one of the international universal specialized agencies, within the activities of all the international universal specialized organizations. For example, the International Labour Organization, its aim is to promote the condition of work of workers. Here we are within a social matter, which is between the aims of the UN. The promotion of trade between states, economic matter, integrated between the aims of the UN, but also it is the ultimate aim of the World Trade Organization. Then, because of this fact, because that the activities of the UN in these fields have many complementarity with the activities of each one of these universal international specialized organizations, then the UN Charter in Chapter 9 stipulates that it will be satisfied, it will be better if the existing universal international specialized organization and also for the future universal international specialized organization which will be created in the future after 1945, it will be favorized, it will be a good thing that each one of them will conclude, if it wants, treaties of cooperation with the UN. Then if we are within a universal international specialized organization who decides to conclude a treaty of cooperation with the UN, he will have the name of UN specialized agencies. On the other hand, if another universal international specialized organization will decide not to conclude a treaty of cooperation with the UN, here he will remain having his title as international universal specialized agencies. For example, the ILO, the International Labour Organization, concluded a treaty of cooperation with the UN and now has the name of UN specialized agencies. It is not so, it is not the case for the International Atomic Energy Agency. It is not the case for the International Atomic Energy Agency. Refused to conclude treaty of cooperation with the UN, and then when speaking about the International Atomic Energy Agency, we are not within a UN specialized agency. Here we are only with a universal international specialized organization. Then each one conclusion, each one of the existing universal international specialized organization is allowed, only allowed, no obligation here, is allowed to conclude treaties of cooperation with the UN, In this case, when a universal international specialized organization decides to conclude a treaty of cooperation with the UN, who will be between the organs, the principal organs of the UN, the parties of this treaty. In one hand, the concerned international universal specialized organization as independent organization, and in the other hand, the partner for the conclusion of this treaty is, by the stipulation of the UN Charter, is one of the principal organs of the UN, not the Security Council, not the General Assembly. It is the ECOSOC, the Economic and Social Council. The Economic and Social Council. We have not examined it in detail, but that is this principal organ who conclude treaty of cooperation with universal international specialized organization, who decide by their proper will, without any obligation to assume here, who decide to conclude treaty of cooperation with the UN within the ECOSOC, the Economic and Social Council. And now, within the exception of the International Atomic Energy Agency, all the other universal specialized international organizations have concluded, in fact, treaty of cooperation with the UN. Then, conclusion, now all the universal international specialized organization, by concluding, in fact, treaties of cooperation within the UN, they have the name of UN specialized agencies, with the exception of the International Atomic Energy Agency, which haven't yet concluded until now a treaty of cooperation with the UN by the ECOSOC. After concluding this treaty of cooperation, the existing Universal Specialized Organization, which concluded this treaty of cooperation, before concluding this treaty of cooperation, all of them, they were, as I said it, independent from the UN. Independent from the UN. International organization having their proper statutes. Proper statutes stipulated in the treaty, which create each one of them. After this conclusion of this treaty, what will be the consequence? As we will say that after concluding one of these treaties of cooperation, the concerned, for example, ILO, International Labour Organization, or International Bank, will go to its end as independent international organization and become one of the organs, subsidiary organs of the UN? Never. We can suppose in the question that they will be principal organs, because the principal organs of the UN are stipulated in the UN, and they are 6 principal organs. But the question remains, after concluding this treaty, their independent legal personality will go to its end, and this Universal International Specialized Organization will become organs of the UN, depending from the UN? The answer is negative. The answer is negative. And this is explained now why we are within a different chapter. Within this case, chapter 7. Because in fact, after concluding these treaties, we are also within Universal Specialized International Organization, having each one of them its proper international legal personality, distinguished from the international legal personality of the UN. Not within a new subsidiary organ of the UN. We can say that the UNESCO, after concluding its treaty of cooperation with the UN, become an organ of the UN. That is not right. The principal organs of the UNESCO, as we will say, are not the same as in the UN. The aims of the UNESCO, only one aim, as we will say, but in the UN we are within 4 aims. The system of vote is not the same. The member state in the UN are not the same in the UNESCO, as we'll say also. Then we are within separate international organization, in one hand, which concluded between themselves treaties of cooperation in the other hand. In the other hand. And we have now to appreciate what is the content of this cooperation. If we are within separated international organization, what will be then the content of the cooperation between the UN in one hand and each one of these international universal specialized organizations in the other hand? As I have said, by the UN Charter, the possibility, not the obligation, for each one of the universal specialized international organization is offered to conclude a treaty of cooperation. No obligation here. But the UN Charter stipulates also that if one of these universal international specialized organizations will conclude this treaty of cooperation with the UN, some legal consequences will arise here, not consequences relating to the extension of the legal personality of these international universal specialized organization. Consequences relating only to the spheres of cooperation which has to exist, to be established between each one of these international specialized organizations which conclude treaty of cooperation with the UN and then become UN specialized agencies and the UN itself. They will cooperate here with which body? First of all, with the ECOSOC, because they conclude their treaty of cooperation with the ECOSOC. Second, with the General Assembly of the UN, because as you know, only the General Assembly of the UN is the plenary organ of the UN. Plenary organ having to realize all the aims of the UN. Then not to cooperate as a principle with the Security Council, for example, because the aim of the Security Council is the implementation and the promotion of the international peace and security, and no one of all the universal specialized international organization has connection with this field, the field of promotion of peace and security. And the only one of them having indirect relation with international peace, that is the International Atomic Energy Agency, which decide not to conclude treaty of cooperation with the UN. Then what are the standards of mutual cooperation? Because here we are within mutual cooperation, not cooperation by this specialized organization with the UN, but mutual cooperation between them. What are the standards of these mutual cooperation? What are the contents of these mutual cooperation? Stipulated where? By decisions of the ECOSOC, for example, by decision of the General Assembly, for example? Never. In fact, that is the same chapter 9 of the UN Charter, which promote the possibility of cooperation between the UN and each one of the universal specialized international organizations, which stipulate what are the contents of these mutual cooperation. One first field of cooperation, mutual representation between each one of these international specialized organizations and the UN within ECOSOC and General Assembly, mutual representation. Each one of these specialized organizations is represented in the UN, have the right to assist without right of vote, to the meeting of the ECOSOC and to the meeting of the General Assembly, without right of vote. Also, the General Assembly or the ECOSOC is allowed, within this stipulation, to assist to the meeting of each one of these international specialized organizations without right of vote. First field of cooperation. The second one, the exchange between UN, first of all, ECOSOC and General Assembly, of informations with each one of these universal specialized organizations, having then the name of UN specialized agencies, exchange of information. Third field, exchange of recommendation between them. Each one of these specialized universal organizations may and have the possibility to give recommendation to the UN, and also the UN within ECOSOC or General Assembly have the possibility to give recommendation to the universal specialized agencies. Fourth field of cooperation, and this field doesn't relate to exchange between them. It is not a case of exchange. The last field of cooperation between them relates to the obligation within the stipulation of the UN Charter, the obligation incumbing upon each one of these universal specialized organizations, having, by concluding the Treaty of Cooperation, the name of UN specialized agencies, the obligation to implement the resolution adopted by the UN and having a relation with their activities and having relation with their activities. I give an example. We are now within the problem of Corona. It is possible for the General Assembly or for the ECOSOC to examine this problem, to find a solution in the aim to make end to it. It is also the aim of existing of the World Health Organization, the promotion of the health in the international community. If the General Assembly or the ECOSOC will deposit a standard relating to make end to the Corona, an obligation will be assumed to the World Health Organization to promote this resolution to implement it, in this meaning, obligation not to adopt a resolution which is in contradiction with the resolution adopted by the UN. All this field of cooperation, as I said now, are stipulated in the UN Charter. In the UN Charter. And as you say, and as you see here, all this field of cooperation stipulated in the UN Charter doesn't affect in no way all this field. Each one of them do not affect in any way the independence of this specialized organization in their relation of the UN. In their relation of the UN. Yes, one of you may retort by saying, but if each one of these specialized organizations has obligation to promote the resolution adopted by the General Assembly, how can we say that they are independent? I give now the answer. The stipulation in the UN Charter say so. The stipulation in the UN Charter relating to this obligation say so. The member states of these agencies has the obligation to promote the resolution adopted by the UN. The member states of these agencies have the obligation to promote these resolution. The stipulation having been, the agencies has the obligation to promote this resolution. And then, by the stipulation of the UN Charter, it is clear now that even these obligations, the only one, even these legal obligations, the only one, which may affect if we do not understand it in its legal signification, doesn't exist no obligation for the specialized organization to promote the resolution. This obligation constitutes an obligation for the member states, Conclusion, we are here with an independent international organization from the UN, having coordination with the UN, because the activity of each one of them, by the treaty creating it, has similarity with the activities of the UN by the treaty which create it, I mean the UN Charter. The UN Charter. Then, after examining this first topic, the theoretical aspects of the UN specialized agencies, why we give them the name of UN specialized agencies, if they are separated international organization of the UN, now we will have to examine today, two of these international specialized agencies, two. In the next course, we will have to examine other two. Today, we will have to examine, number one, the International Labour Organization, number two, the UNESCO, and in the next course, we will examine the International Monetary Fund and the International Bank. Beginning with the International Labour Organization, the ILO. I said now we will examine 4 specialized agencies: International Labour Organization number 1, UNESCO number 2, 3 International Monetary Fund, 4 the International Bank, International Labour Organization, UNESCO, International Monetary Fund, and the International Bank. Beginning with the International Labour Organization. In fact, we have to know, first of all, that the International Labour Organization is between the Universal Specialized Organization and also in its relation with the UN, the oldest international organization created in the 20th century. Why? Because, in fact, the treaty creating the International Labour Organization has been created in 1919. And the treaty creating the ILO was the same treaty creating the League of Nations. The League of Nations. I mean the Treaty of Versailles. The Treaty of Versailles. The Treaty of Versailles, which created the League of Nations, 1919, created also the International Labour Organization. We have now to examine the International Labour Organization by examining more than one topic, one axis. We have to examine many axes relating to the International Labour Organization. Number one, composition of the International Labour Organization. Number two, principal organs of the International Labour Organization. 3, the aims of the International Labour Organization. 4, how does each one of these principal organs of the ILO meet? 5, the system of vote in the principal organs of the ILO. And last point, the legal effect of the resolution and sometimes the conventions adopted by the ILO. Number one, composition. All the member states of the UN and the members of the UN now, as you know, are 193 states, are also the members of the International Labour Organization, the International Labour Organization. Number two, aim of the International Labour Organization stipulated in the Treaty of Versailles, only one aim, because here we are within specialized international organization, each one of them having only one aim to realize. And the aim of the ILO, within the stipulations of the Treaty of Versailles, is to promote the condition of work of workers. The promotion of the condition of work for workers. The promotion of the conditions of work for workers. Only this is the aim of the ILO. Only this is the exclusive aim for which the ILO has been created. What are the principal organs of the ILO? As you know, in the UN, within the stipulations of the UN Charter, we are within 6 principal organs. 6 principal organs, between them, plenary one, including, in one hand, the plenary one, the executive one, the secretariat, and 3 other principal organs. Between them, between these 3 others, a court, the International Court of Justice. But as a principle, in all universal specialized organization, but also, as we will say later, in regional organization, in regional international organization, as Arab League, for example, their composition, the composition of the principal organs of each one of them is reported. 3 principal organs. Only 3 principal organs. And that is the case here within the ILO. Number 1, the plenary organ, having the name of the conference. Number 2, the executive organ, having the name of the council. And third, the third organ is the secretariat. The third organ is the secretariat. Plenary organ, executive organ, and secretary in an universal international organization as in the UN. The International Labour Organization is an universal international organization as the UN, as UNESCO. And then to examine the composition of these 3 principal organs, we apply the rule promoted in the general theory of international organization. We have examined it before. The Secretariat composed by agents of the organization who doesn't, each one of them, represent his national states, but in the plenary organ and in the executive organ, we are within representatives of states. In the plenary organ and in the UN, the conference, all the member states are represented. All the member states are represented. It is not the case in the executive organ, because as in the UN and in the general theory, in the executive organ, only some of the member states of the concerned universal organization are represented in the executive organ. And their number is stipulated in the treaty creating the concerned international organization. And it is so also in the ILO as in the UN. In the UN, all the member states of the UN are represented in the General Assembly. In the executive organ, the Security Council, only 15, as you know, including 5 permanent members. Including 5 permanent members in the Security Council. How is composed the plenary organ in the ILO, then, of all the member states of the International Labour Organization? And because I have said now that we have now 193 member states in the ILO, then all of them are represented in the plenary organ. In the executive organ, here we are within an organ of limited membership, as in all universal organizations, an organ of limited membership. In the Security Council 15, 10 non-permanent and 5 permanent. But these 5 permanent are stipulated by their name in the UN Charter, as you know. What is the situation relating to the limited membership in the ILO, in the executive organ? In Security Council 15, in the ILO, in the executive organ, but also in the plenary organ, each state is represented in the plenary organ, as I have said. In the executive organ, an organ of limited membership, we have only 28 states represented in the executive organ of the ILO. In the Security Council 15, in the ILO, in the executive organ, 28, including the 10 most developed industrial states, including the 10 most developed industrial states. Then, for these 28 states represented in the executive organ, in one hand, 18 not representing the most developed industrial states, and they are elected by the conference, by the plenary organ, within the criteria of the equal representativity between continents, as you know. 18 states elected by the conference with the promotion of the criterion of the equal representation of all continents. The other 10 represent the most industrial developed states, elected also by the plenary organ, but between the most industrial developed states. And here, no equality then between states. No equality then between states. But these 10 states are not stipulated by their name in the charter of the ILO. And then, conclusion, the 10 states represented 2012 in the executive organ will not be the same in 2019 because of the fact that the most developed state in Australia change from year to year, change from year to year. That is relating to the principal organs of the ILO. System of meeting. As in UN, the conference meets once a year, and in the executive organ, it meets in permanence all the year. It means it meets in permanence all the year. The system of vote. The system of vote in the International Labour Organization. Here we have to appreciate, in fact, to distinguish things, to distinguish points. The first one relates to what are the number of right of vote recognized to each member state in the plenary organ and in the executive organ. Number of vote recognized to each member state. All the member states in the conference and to the 20 states represented in the executive organ. As you know, within the general theory, each member has only one right of vote. Only one right of vote. In the plenary organ and in the executive organ. That is not so in the ILO. Without distinction between the conference and the executive organ. It is not so. Why? Because each state each state has 4 right of vote. Has 4 right of vote. Then Egypt in the conference has 4 right of vote. And if Egypt is represented in the executive organ between the 18 states, will have also 4 right of vote. 4 right of vote. How these rights of vote are recognized in the ILO, in the Treaty of Versailles, I mean. In fact, the composition of the delegation of each member state then is a conference, the plenary organ. In fact, each member state is represented in the conference by 4 representatives. By 4 representatives. Each one of them having 1 right of vote. Having 1 right of vote. Then the delegation of each member state have 4 right of votes. Not only 1 right of vote. How and why? In fact, because knowing that the International Labour Organization has been created to promote the condition of work for workers, in fact, and that is an originality within the composition of the delegations of states in IOS, in the International Labour Organization, the representatives of each state in the conference is realized by a system giving for each member state the right to design 2 representatives in the conference. Then each state has 4 representatives. The government of the state have the right to design 2 between them. 2 between the 4 representatives of the states are designed by the state, by the government. The third one is not designed by the government of the member states. The third one is elected by the syndicate of workers in that state. The fourth one is elected by the syndicate of the enterprise of these states, by the syndicate of the employers of these states. Then 2 designed by the government of the state, third one elected by the syndicate of workers, and the last one elected by the syndicate of the employers. And each one of them has 1 right of vote. 1 free right of vote. Then it is possible that the 2 representatives of the state will vote yes for a project, and the representative of the workers will vote no. Will vote no. For right of vote for each member state in the conference. That is the situation. In the executive organ, I've said now that we are within 28 states represented in the executive organ of the ILO. But in fact, if we are within 28 states, including the 10 most developed states, in fact, we have 56 right of vote in the Council. 56 rights of vote. How? 28 for the representative of government, 14 for the representatives of workers in the same state, and 14 for the representatives of the syndicates of employers in that state. Then 28 member states having for each one of them one right of vote in the council, but also 14 for the syndicate of workers and 14 for the syndicate of employers, which then explain us why we have in the council, despite the fact that they are represented in the council by 28 states, we have 56 rights of vote, because we have 56 seats in the executive organ of the ILO. The majority required here. The second point relating to the system of vote. The majority required to adopt a resolution. In the plenary organ, simple majority of the voting state. Simple majority of the voting state. Then, without taking into account the absent state or states which decide not to take part of the vote. The simple majority. In the executive organ, always the majority required is 2/3 of the voting states. 2/3 of the voting states. 2/3 of the voting states. Last point to examine here, the binding force of the resolution adopted by the principal organs of the ILO, I mean the plenary organ and the executive one. The resolution adopted in one hand by the plenary organ constitute by themselves recommendation. And here we apply the principle relating to the binding force of recommendation. When adopted, binding for the states who vote yes. When adopted, not binding for states who vote no. But within the time, it is possible that these recommendations become binding even for the states who vote no, if these recommendations become in the future rules of customary law. binding by the procedure of customary law. That is in the conference. The plenary organ adopts then not binding resolution by themselves. It is not the case for the resolution adopted by the executive organ of the ILO. All the resolution adopted by the executive organ of the ILO, and always they are adopted, as I said now, within the majority of the 2/3, at least, are binding for all the members. Then even for the states who vote no. Is it enough? No. By the Treaty of Versailles, also, it is stipulated that the resolution adopted by the executive organ of the ILO, their binding force is established not only in the international mutual relation between the members, but also each one of the resolution adopted by the executive organ must be implemented in the legislation, in the internal legislation of each one of the member states. Then, obligation for the member state of the ILO to integrate the binding resolution adopted by the executive organ of the ILO in their proper internal legislation, in their internal proper legislation. What will be the situation if a member state doesn't integrate this resolution in its legislation? What will be the sanction? In fact, here the executive organ of the ILO, in one hand, and the other member states of the ILO, in the other hand, are allowed to present a claim within the executive organ of the ILO against the state which doesn't implement this resolution in the internal system, in its internal system of law. Then a penalty here, a claim can be represented against this state before the ILO by the executive organ in one hand, and also by the other member state in the other hand. And in factual examples, in many cases, some member of the ILO and the executive organ of the ILO itself presented claims against all member states, Egypt including. That is relating to the ILO, composed, as you know, by the same number of states, member of the UN. Going now to examine the other Universal International Specialized Organization, being now UN Specialized Agency, I mean the UNESCO. I mean the UNESCO. And as I have said, you have not to examine the FAO. You have not to examine the FAO. The UNESCO. The UNESCO. How is composed the UNESCO? The number of member states, member in the UNESCO. In fact, they are 194 states. The member states of the UN, 193. The member states of the UNESCO are 194. Why? Because Palestine is now a member in the UNESCO, but haven't been in the possibility to be member, acceded member in the UN because the veto of the United States in the Security Council, And after the admission of after the admission of Palestine in the UNESCO, the United States of America decided to leave the UNESCO than to prevail of its quality of member. What are the principal organs in the UNESCO? As in the ILO, we are within a tripartite composition of its principal organs, plenary one, executive one, and secretariat. What is the aim of the UNESCO? Only one as for the ILO, but distinguish one. The aim of the UNESCO, and the UNESCO has been created in 1946, is always to promote education, science, and culture. That is the aim of the UNESCO, the promotion of education, science, and culture in the international community. An aim which is common to the competences of the General Assembly. But in the UNESCO, the composition of the plenary organ and the executive organ is more simple than in the ILO, because the delegation of each member state are designed only by the government of these states. Then in the plenary organ, all the member states, 193, are now 194 because the accession of Palestine to UNESCO, 194 are represented in the conference, plenary organ. In the executive organ, we have, in the executive organ, only the possibility for 58 states to be represented in the executive organ, because the executive organ of the UNESCO, as all other universal international organization, is an organ of limited membership. And all the states represented in the executive organ of the UNESCO are elected by the plenary organ within the criteria of equal repartition between states. Then no possibility for permanent representation for some most powerful states, as in the UN or in the ILO. The greater states, as the non-greater states, are equal in the representation in the executive organ of the UNESCO. How? By the criterion of the equal representation by continent, without any distinction, The system of meeting in the UNESCO, the conference once a year, the executive organ meets in permanence. The system of vote, one right of vote for each member state, not as the ILO, as in the UN, one right of vote for each member state. The resolution, the majority required for the adoption of resolution in the conference, always, in the conference, the plenary organ, always simple majority of the voting states. In the executive organ, as a principle, 2/3 majority of the voting state, as in the ILO. The resolution adopted by the plenary organ within the simple majority are recommendation. And their legal system then is as in the general principle and as in the ILO, as we have examined now. The legal system of the resolutions adopted in the executive organ of the UNESCO is not as in the ILO. The resolution adopted by the executive organ of the UNESCO are constituted by recommendation, have then the legal force of recommendation, with only one exception. What is this exception? If we are within a universal treaty adopted under the auspice of the executive organ of the UNESCO. In this case, because we are within a universal treaty concluding by the member state, but within the auspice of the executive organ, here this multilateral treaty will be considered as binding for its parties, not for the non-parties. Then, not for states which decide not to ratify this treaty. That is relating to the three topics we have decided to examine today in this chapter 7. Chapter 7, yes. First topic, the theoretical aspect and problematic relating to the concept of UN specialized agencies. Number 2, an examination of the International Labour Organization. Number 3, an examination of the UNESCO. Then, from page 221 to page 233 within excluding from the exam of the Food and Agriculture Organization, I mean the FAO, which exists from the last paragraph of page 230 to the beginning of page 232. 32. For our next course, from the last paragraph of page 233, I mean International Civil Aviation Organization, to the first part of page 235 is excluded also from the exam. Then we have examined International Labour Organization, UNESCO, excluded from the exam, the FAO, and also the International Civil Aviation Organization. International Civil Aviation Organization. In our next course, we will examine page 235, International Monetary Fund, 235, 236, 237, 238, International Monetary Fund, and then the World Bank, and then the World Bank, then to page 242, 242. And this will be all for this chapter 7. For chapter 7, then we have to examine only for the exam the theoretical aspects of UN specialized agency, 2, the ILO, 3, the UNESCO, and we have examined these 3 topics today. Next course, we will examine from page 235, I mean International Monetary Fund, to page 241, I mean International Bank. International Bank. Then for the exam relating to this chapter, we will have to examine 1, the theoretical aspect of the notion UN specialized agencies, 2, ILO, 3, UNESCO, 4, International Monetary Fund, 5, the International Bank. The International Bank. And the International Monetary Fund and the International Bank, we will examine them in our next course. Thank you so much, and see you later on the system of online. Bye.